How do indemnification and limitation of liability work together in contracts? Imagine signing a contract where one party promises to cover certain costs if things go wrong, but at the same time, there's a cap on how much they might have to pay. How do these two ideas fit together? Well, they are like two sides of the same coin in managing risk. Indemnification is a promise to protect or compensate the other party for specific losses, often from third-party claims. Limitation of liability sets a maximum amount or scope of damages that can be claimed or paid. Let's say a software company agrees to indemnify a customer if someone sues over intellectual property issues. That means the software company will pay legal fees or damages if a third party claims the software infringes on their rights. But the contract might also include a limitation of liability clause that caps the total damages the software company has to pay, maybe to a certain dollar amount. This means even if the damages are high, the company won't pay more than that cap. Now, these clauses work best when they are clear and aligned. If the indemnification clause says the company will cover all damages, but the limitation clause caps damages at a small amount, confusion can happen. The contract might not specify whether the cap applies to indemnity payments or not. This can lead to disputes if a claim exceeds the cap but the indemnification obligation is still in place. To avoid this, contracts should clearly define what the indemnification covers, including any exceptions like negligence by the indemnity. They should also specify how the limitation of liability applies to indemnification. For example, does the cap include indemnity payments or are those unlimited? Using straightforward language and placing these clauses prominently helps everyone understand their limits and responsibilities. Sometimes, parties choose to limit liability only for certain damages and not for indemnity obligations. For example, they might exclude consequential damages from the cap but allow unlimited coverage for third-party claims under indemnification. This way, they balance risk without exposing themselves to unpredictable losses. In the end, these clauses are tools to allocate risk fairly. Properly drafted, they work together to protect both sides from unexpected or excessive financial burdens. When negotiating a contract, paying close attention to how indemnification and limitation of liability interact can save a lot of trouble later. Clear, precise language ensures everyone understands their responsibilities and limits, reducing the chance of costly legal errors.